Chalo, so now we will discuss the Article 32, and here we will discuss 32 plus 226, the writ of the High Court and writ jurisdiction of Supreme Court, with comparing the power to both. This is writ jurisdictions. So Supreme Court having a writ jurisdiction under Article 32, whereas in Parliament having a writ jurisdiction under 226. It's clear? Now, if we see the power of or jurisdictions, if we talk in the terms of jurisdictions, so this Supreme Court power under Article 32 is lesser with respect to issue of writ, while the power under High Court under 226 has a wider power to issue writs. To issue writ. Now, how we can say that it has a lesser power? Because, yes, so because the Supreme Court or anyone can approach to Supreme Court under Article 32 only for the violation of fundamental rights. So Supreme Court can issue writs only for the violation of fundamental rights, none other than the, so Supreme Court is not going to entertain any type of litigations under Article 32 except the fundamental rights, except the violation of a fundamental right. Is it clear? Right? So only for fundamental rights. But whereas the power to the High Court under Article 226 is wider because it has a power to issue writs for the fundamental rights also and for the other legal rights. Like taxations, if state makes any taxations on the individuals, so they can move to the High Court under 226. Are you getting my point? And because of this features of the Supreme Court, it is made the mandatory. So this under is mandatory. So Supreme Court cannot, mandatory means it cannot deny the issuance of writs. Whereas a writ under 226 of the High Court is discretionary. It means it can refuse to issue writs, but it cannot refuse to issue writs even on the technical ground, even on technical ground. Or the Supreme Court cannot refuse the writ under 32 by saying that you have not approached to High Court. Go and first approach the High Court. Why did you not avail the power under 226? It cannot also say that. So by any means, the Supreme Court is made an mandatory, or it has been obliged by the 32 that they have to entertain the writ under Article 32. They have to issue. Either no ground is been then to reject the petitions under Article 32. Yes or no? Is it clear? But the 226 itself provide that the High Court, though it has a power to issue writs with the fundamental rights or with the other legal right like taxations or any rights, it can refuse to entertain the fundamental rights. Yes or no? Is it clear? Right? You can write one example with respect to the other legal rights, that what can become under the legal rights. So you can write that a state legislature, where a state legislature has imposed a sales tax. We are writing an example with respect to the other legal rights, where a state legislature has imposed a sales tax in contravention of the limitation imposed by Article 286, in the contravention of the limitation imposed by Article 286. 286. I said 226. 286 na. Then third difference, if we see that in terms of territorial jurisdictions, Supreme Court jurisdiction is wider. Means whatever the order issued by the Supreme Court will be applicable to territory of India. Whereas High Court territorial jurisdictions is lesser, because only applicable to the state high court jurisdiction territory concerned high court territory. Certain high courts have a different or many of the jurisdictions of other states also, like Calcutta High Court has a jurisdictions of Andaman Nicobar also, right? Similarly, the Bombay High Court also having a Dadar Nagar Havelis on. So certain high courts applicable to concerned high court territory. So this is the difference between the 226 and 32. It's clear? So when we will do the judiciary, we are now we are not going to discuss the writ jurisdiction of Supreme Court nor the writ jurisdiction of High Court under 226 and 32, because we have discussed. We will discuss it here only. Territorial jurisdictions. हाँ, दिल्ली हाई कोर्ट अगर कोई परमिशन, कोई रिट इशू करेगी, कोई डायरेक्शन इशू करती है, अगर कोई ऑर्डर इशू करती है, तो सिर्फ दिल्ली हाई कोर्ट टेरिटरी तक ही होगा. दिल्ली हाई कोर्ट का ऑर्डर यूपी नहीं मान सकता, यूपी हाई कोर्ट नहीं मानेगी, यूपी टेरिटरी में लागू नहीं होगा. फॉर एग्जाम्पल, यू कैन अंडरस्टैंड, if this institution's directions issue any order, that will be applicable to everyone. But if I issue any order, it will be applicable only to the class. So any high court अगर issue करती है order, जैसे आप दिल्ली की बात करें, तो दिल्ली हाई कोर्ट ऑर्डर will be only applicable to the territory of Delhi extent, या जो इसके हाई कोर्ट में आते हों. Yes or no? जैसे आपका पंजाब एंड हरियाणा हाई कोर्ट हैज two state and one UT jurisdictions. So whatever the order of the Punjab and Haryana High Court will be applicable to all the three, but not beyond the three. I get my point? हाँ, जो उनका jurisdictions है वहीं तक. इसलिए मैंने यहाँ पर टेरिटरी नहीं लिखी है, कंसर्न हाई कोर्ट टेरिटरी लिखा है, स्टेट टेरिटरी नहीं लिखा है. You need to understand this. I'm not talking about the state jurisdictions. I'm talking about the high court territories. जैसे for example, I give you the example of Bombay High Court, Calcutta High Court. So it is not only limited to the West Bengal, rather Andaman Nicobar is also been included or covered under the Calcutta High Court. So whatever the directions issued by the Calcutta High Court will be applicable to West Bengal plus Andaman Nicobar. But whatever the direction issued by the Supreme Court is equally applicable to every nook and corner of the India. And violation of this directions of the Supreme Court is to be considered as a contempt of court. Then it depends upon if the individual fundamental rights is infringed by the any action of legislature or executive within that territories, then it can approach to the High Court. अगर किसी का rights यूपी में infringe हुआ, तो he cannot approach the Delhi High Court. He has to approach the Lucknow Allahabad High Court or Lucknow bench of Allahabad High Court, right? if any actions of there is been approached. So there have that it will be applicable, and if any directions given under this, that is to be applicable within that territory. But if that person does not want to go to the High Court, directly they can approach to the Supreme Court. Only they have to mention why they do not go to the High Court. But on that ground, the Supreme Court cannot reject the petitions. कि आपकी वो रेमेडी थी, आप क्यों नहीं उसको अवेल के लिए. Are you getting my point? Right? Any questions? Sorry, High Court? Yeah, sure, that can take through the cases. That can be quoted by the counsel also. This High Court has given us judgment with similarly to this kind of cases with this regard. So they can take inspirations. But it is not necessary they should follow. It depends upon the circumstances. We should understand that identically should not be similarity. We should have a similarity. We can provide a similarities of this. So they can take an inspiration, yes. Similar, we have an integrated judiciary. तो हम ये तो कह ही नहीं सकते कि वो उससे competitions में है. No state high court is in the competitions. Is this clear? Any doubt? Right? So here we have seen the features of the 32. We have discussed the differences between the High Court power and Supreme Court power under 32 and 226. And because of this feature of the Supreme Court under 32, it has been regarded as a guardian and protector of the fundamental right. Guardian of the fundamental right. Now what is the role of a guardian? Is to protect its child by any means. So it has been given that power that you have by any means you have to protect the fundamental rights. Is this clear? So पहले यहाँ तक लिख लेते हैं.